privilege of understanding and putting out what we read in the law. Whilst we take your position to stand down or have my colleague as being out of order, I reiterate your statement at the beginning where you indicated that this is indeed a house of laws. You have every machinery to counter-check the truths or half-truths that then would have been said in these debates. But that notwithstanding, the issue relating to the orders issued and as attached cannot then be thrown to the wind. These are standing orders and they are binding. Not only to us, but to everybody who's mentioned in that particular case. We cannot assume or pretend that they're not binding. They are binding. Mr. Speaker, I will proceed to the allegation to save on the time of this Honorable Assembly. I'd like to point out that ground 1 to ground 7 to ground 6, Mr. Speaker, sir, relates to the actions of His Excellency the Governor following to the letter of the separation of powers between the executive and the legislature. He got communication from the speaker sitting then. It's not for the governor to come and check on what has been discussed in the House. The governor receives directions through the clerk, not even through the speaker, through the clerk, of what has been held and deliberated in this House. The governor was served with gazette notices, which are binding. And the mover of the motion has pointed out that the governor was not following the law. But the governor is here served with gazette notices, which are binding, which in essence are the law. How then can he be accused of following one gazette notice and not following the other? We cannot cherry pick, as the mover of the motion said, on what to follow, not to follow. It's not on us. We do not have the standing whatsoever to choose on what to follow and what not to follow. The governor does not have, the speaker doesn't have, and neither does any member of the assembly.
Lady Council, are you aware that the same governor resubmitted the budget that was handled in the said to this House?
Ayona, I will come to that.
Thank you. Proceed.
Just allow me to ventilate on my issues, and then you can point out what you find not in alignment. So then, how then can we come to these honorable laws? How can the mover then stand and say that the government is in violation of the law, when indeed, up to the point that he followed these deliberations from Bunge Mashinani, they stood as the law up until the Bomet case was up and it how then is it the governors are doing? The issue of bunge mashinani can be ventilated in this house till the end of the day, and I know because of the differences, Mr. Speaker, sir, that we have in the house, I doubt that ever we'll come up with a conscious decision. Mr. Speaker, there is a letter dated 12th June 2025. I'm responding to particular number 1.6, the failure to appoint the chairperson. There is a letter dated 12th of June 2025 from the County Assembly. On the interviews of the members of the Public Service Board, and the County Assembly stops the governor, stops the County Secretary from proceeding with the interviews of the members of the County Public Service Board. This same assembly that is accusing the governor of not appointing a County Public Service Board sent communication to the County Secretary stopping him. Then to the move of the motion, we wonder, is it that you were not in the assembly? Is it that you were not alive to the proceedings of this letter dated the 12th of June 2025? Or is it a case of shooting in the dark and hoping to reach a target? On particular 1.7, the gross violation of the Constitution by failing to submit annual reports and deliver annual state of the county addresses. It will be noted that that's found in page 11 of our response. It will be noted that reports have always been submitted to the County Assembly, and we have annexed them in our response. The County Annual Reports June 2023-2024 submitted to the Assembly on the 25th of January 2024. The County Annual Reports June 2024-2025 was submitted to the Assembly and received on the 31st of July. The Budget Implementation Report 4th quarter 2023-2024 was submitted to the Assembly and received on the 30th July 2024. The list goes on and on. Mr. Speaker, we wonder once again, did this escape the move of the motion? Or once again, is he just throwing punches, hoping to hit the target? What we find very peculiar and very interesting, Mr. Speaker, is ground number 1.8, where the mover says the county lost a lot of money. In his words, colossal amounts of money, because of the delay or refusal, or the failure, in his words, failure to appoint and obey court orders. What the mover fails to understand is that in that same court order and ruling in Kisumu ELRC number 10 of 2021, this house, the County Assembly, is faulted by the judge for failing to carry out its duties in the appointment of Clive Ogwora. But what has the mover done? In total in total disregard of separation of powers. He's lumped it on the government. Mr. Speaker, I'll point you to page 177 of our response, where the court states, you'll bear with me, I will read it. The third respondent, Mr. Speaker, the third respondent here being the County Assembly. Our governments were clear that once the nominees and the public were notified of the approval hearings, nothing happened in relation to the applicant's approval for appointment or rejection. Nothing happened from this house. This house did not address the court on what transpired after the hearings. The third respondent only said that her committee facilitated public participation and openness. I'll go to the end. No mention of the result of the vetting process. The vetting is done in this house. There is no mention of the result from this house. But what has the mover done? Lump it at the doorstep of the government. He talked about loss of funds. So, Speaker, I'll point you to page 178. Paragraph 35(4) of the judgment. It reads that the cost of the proceedings be borne by the third respondent.
Yes, Honorable Leader Majority.
Thank you, Honourable Speaker. I wish to move a motion for this House to extend its sitting hours or sitting time. Pursuant to Standing Order 29, subsection 1.
That the court did in paragraph 35(4) of its judgment find this house culpable and ask the court this house to pay costs. Again, Mr. Speaker, sir, the losses that were incurred in this particular case did not come at the point of judgment. These losses incurred came way after the order on costs was not honored by this particular house. What have we done? Lumped it on the doorstep of the government. My Lord, something else, Mr. Speaker, my apologies. Something else that we ought to not, we would, as a person, I would be very concerned on cases of misappropriation of funds. And the House has been told that there was an improper, I'm referring to 2.1, there was an improper use of authority of the Speaker's authority, the government authority in recruitment of the staff without approved budgets. Mr. Speaker, on page 13 of our responses, we've labored to show the exits, number of officers who exited service to this county, and the wage bill saved therein. And it goes a long way to show that indeed the governor did not disregard the freeze on employment. And in any case, the motion, in particular 2.1 of this motion, the advisory was issued after the recruitment. That advisory cannot be applied retrospectively. What would happen if that advice is applied retrospectively? That means that this county then would incur losses from numerous litigation cases because these people had been handed their letters of employment. It's been shown that there was indeed gaps, and these Mr. Speaker, would also address the purported issue of dual appointments and creation of official vacancies. We presented concrete evidence. This House in the motion was not presented even with an iota of evidence. Just hearsay. Where it comes from, they would call it stories jaba. Nothing was presented to show that indeed there was any dual appointment. And in any case, I'm sure this House has many bright members. I've seen my senior here. How then would it miss? How then would it miss the House that the role of appointments is not under the purview of the governor? This falls right under the County Public Service Board. Has anybody in the County Public Service Board been called here or been mentioned in this motion? None whatsoever. A classic case of witch hunt. The purported freeze is addressed to the CEO of the County Public Service Board and copied to the Speaker of this House. Nowhere is the governor mentioned. On the recruitment of the Deputy County Secretary, the County Attorney, and support staff, and quite a number of people, the appointments were done by the County Public Service Board, which is an independent body. My senior would bear me witness, Mr. Honorable Juma. Well, if you decide to abandon the law today, but this is clear in the law, Section 59A of the CGA Act. These appointments.
Can we address the chair? Address the chair.
My Lord, in our training, we always ask to respect our seniors. You'll bear me witness, but I stand guided. But what has been done by this motion, the employment of these officers, where there's a body mandated by law to perform such functions, has been lumped on the doorstep of the government. Mr. Speaker, these and 2.2 and 2.5 are clear allegations which do not at all touch on the office of the governor. Our response to 2.6, Mr. Speaker, I pray that you add me 5 minutes when the Honorable Leader of Majority decided to give me more time, but I think when you came in, we'd already gone beyond it. Just give me 5 minutes, it took my time. Thank you very much. So, my Lord, that, Mr. Speaker, so that addresses 2.2, 2.4, 2.5, 2.6. I wish the House or the move of this motion would have put these things together instead of, just tabulating them and making them look like a mountain when indeed it's a storm in a teacup. I will move to 2.4, where the issue that there was a well-orchestrated syndicate where teachers were paid colossal amounts of money, 3,700,000, 1 point something, and 25 million. Mr. Speaker, nothing, I do not know the understanding or how it works, but common practice is that a pay slip does not mean you've earned that money. Nothing has been presented before these honorable House to show that indeed this money did hit the accounts of the teachers. We've gone ahead to attach the statements of one of the teachers, and it does not show. Just, it's like a provisional license, Mr. Speaker, sir. It does not warrant you to drive. You can, the things, it's limited in its application. That is what a payslip is. But it's been presented to this court as the gospel, sorry, in this house, as the gospel truth, when it's just hearsay, innuendos. It stands on nothing. That this person did interfere with the payroll, and as a result, several organizations have lost money because he did give out fake accreditations to people who are not county staff or county officers. As a result of this, the county did ask for technical support from the national government to capacity build at the Human Resource Department and payroll officers. The request was submitted by a letter dated CAN 2.218, it's there, and it is supported by the Constitution Article 6, subsection 2 of the Constitution. Says the governments at the national and county levels are distinct and interdependent, and shall conduct their mutual relations on the basis of consultation and cooperation. And it's in the Constitution. That how is it the undoing of the government? Lastly, Mr. Speaker, sir, 2.7 talks about abuse of office by purporting to suspend the secretary to the Public Service Board. Mr. Speaker, we saw a letter in the motion, one of the attachments, and under section 58(5)(b) of the county government, the removal of a board member is a function of the county assembly and of the governor. The governor did not suspend or purport to exercise these powers of removal. Our client, His Excellency the Governor, tells us he has never seen that letter. It did not come from his office. And I'd like to point these honorables to 15A, which is an order of the court. And before that, there is a letter addressed to the court before this order, where this particular letter is referred to as the impugned letter. There is no admission from the governor that the letter came from him. There is no response from the governor. But he's gone ahead because it didn't come from him. This officer was working. But the move of the motion found it that indeed the governor did suspend. Mr. Speaker, it's common knowledge that this particular officer did serve to the end of her tenure. Under consent from both parties. There is no, ideally in court you put in a response when you're fighting something. But this letter was non-existent. But they said the officer went to court under the guidance of the county attorney, who had never seen the letter, and under the advice of the governor. The governor said, I've not stopped this particular officer from working. So, how then does a matter that has been concluded by court and found to not touch on the governor later on come before this assembly as an undoing or the undoing of the government? I wish we had more time. There is an issue we would have addressed, but I would like to echo. Unfortunately, Mr. Speaker, sir, the mover is, I thought he was sleeping. And unfortunately, there are things I agree with him. The move of the motion says the people of Nyamira deserve a leader that respects the law. That is the current governor. He's not been tried or found wanting. We may have feelings, but again, as we started, we said this is a house of law. It's not a house of feelings. If everybody was to apply their feelings, maybe I'd have the highest feelings. maybe the chief would have his highest feelings here. But these are house of the law. We are constrained under the law. From the foregoing, the governor has been able to demonstrate from all grounds set in this motion to seek to impeach him that they lack legal basis and acumen as enshrined under Article 18(1) of the Constitution of Kenya. The governor has demonstrated, not in detail as we would have, but we've submitted the document which is in detail, that he neither in any way grossly violated the Constitution nor abused the office.
Thank you.
I'm
Thank you.
finishing. It's my last paragraph, Mr. Speaker.
Thank you.
Can I finish?
Yeah. Finish.
If I may bring it to the attention of the House, which is common knowledge, this is the third time an impeachment motion is being moved against the governor. That notwithstanding, it's just a corner in the road, not the end of the road. The governor has diligently discharged his duties to the great county of Nyamira. He served his constituents selflessly. There is no constituent of Nyamira who's ever moved to impeach the governor, save for one who's vested with office. The governor has worked selflessly to ensure that the constituents of Nyamira fully enjoy the fruits of devolution. Mr. Speaker, the definition of gross violation laid out in paragraph 233(2), it says it's not every violation or breach of the Constitution that is or can lead to the removal of a governor. Not every. When you look at this, it's under those not every. They cannot lead to the removal of the governor. That's its humble appeal to the House, Mr. Speaker. And we appeal to the honorable members, whom we truly respect, that we ought to work in concert, to discharge our mandate.
Order. Honorable Duke Masira, order. Order. Honorable Ken Atuti, order. Dekram,
It's
order.
our humble appeal to the honorable members that we ought to work in concert. We here refers to His Excellency the Governor and yourselves to discharge the mandate as the elected leaders of Nyamira County.
Thank you.